I do, Mr. Chairman.
For what purpose does Mr. Bishop seek recognition?
Move to strike the last word.
Gentleman is recognized.
I think the point's quite relevant, and the situation is we're talking about a need to conform all of the salaries of judges in the territories who are subject to presidential reappointment every 10 years.
Would the gentleman yield for a second?
Yes, sir.
Salary is already the same.
Well, okay, salary.
We're talking about retirement benefits.
Fair point. So salaries have already been rendered the same, and there's a good question whether they should be, in my view. And so now we're talking about conforming retirement benefits. Thank you, Mr. Chairman, for the clarification. But the same questions arise. I just wonder, I hear that the notion is conform them to the Article III judges and to the, maybe not entirely, but to the Court of Claims judges, who are also subject to presidential reappointment, but they're not Article III judges. And I just look at what the thing that struck me here, as I sit here at almost 58 years old, is the notion that we're going to make them eligible for retirement benefits after reaching the age of 50. I encountered a thing like that in the state legislature on some retirement mechanisms. I think most Americans would look at us here and say, what in the world? In an environment where, generally speaking, except for the rapid increase in murder rates precipitated by abysmal defund police rhetoric and the like, and Soros DAs and so forth across the country. But as a general proposition, life expectancy has been increasing. And people talk about sometimes over time whether our Social Security system
would the gentleman yield for a second?
Yes, sur. I will.
I just point out that yes, they're eligible for pension at 50, but they have to serve a minimum number of years, and they can't control whether they're reappointed.
10 years, Mr. Chairman. 10 years. And then they can retire at 50. There are rumors that go around on the internet about what members of Congress get. Actually, some of the guys who've been here a long time, they do get a lot. Generally speaking, though, it's very modest, that's beside the point, though. The real point is, I just think people would, the ordinary guy who's out there working for a living and is looking around this country where lots of people are being paid not to work, would look at those numbers and just say that's absurd. And also, it's not the only point that you can work. If you've served for 10 years as one of these territorial judges, you can now, under this bill, you can lower the retirement age so they can leave at 50. And I think I'm not sure exactly what the retirement benefit is, but I think it's really close to their salary. Whatever, maybe somebody can clear that up for me when they have an opportunity to speak. But you've also got the fact that this addresses the ability of judges to serve in senior status. They can voluntarily take senior status. That means they get a far diminished workload, as I understand it, and they get, almost all of their compensation. And the rules on that are pretty lax. And then if you don't even meet the 15 years of the rule of 80, you can get a proportional part if you've served for 10 years. I just don't know what world we seem to live in Washington. That's crazy. Most Americans are working hard, and they're working until they're 70 or 75 years old. It's insane. And I say that as a member of the bar for 29 years. Well, longer than that now, I guess, practicing for 29 years. And I'm sure I say it and offend a number of members of the bench. I do know, it's true, that most people who sit on the Article III bench throughout the country could have their choice to work in a private law firm and make far more. I also got to tell you, I know what their lifestyles are like. And for the most part, it's a lot harder to practice law in a private firm and make that kind of money than it is to be an Article III judge. So I just think, and again, this is outside what the Constitution requires in terms of not reducing pay for lifetime tenure. I just don't get it. And so, I yield to the chairman.
The intent is to foster judicial independence.
Well,
that's the real intent.
I'll tell you, and maybe that's a hotly debated topic in the country too. Most Americans believe that the judiciary is highly politicized because of the predilections of the judges who are on the bench. And one way to fix that is to have the political branches appoint and confirm new judges. So it doesn't make sense to me that insulating judges further so that they can carry out political decisions and be beyond the reach of the people to correct over time is what should be the objective. And it almost passes without comment in this committee. I guess I'm an outlier. So be it. The gentleman from Arizona, and nor did I make it about politicization. What I spoke to was, and let me put a fine point on it, district court judges, and these judges who are not Article III judges, not appointed for life under the Constitution, judges in territories appointed every 10 years by the president, like the Court of Claims that considers claims against the United States government, those judges, both all appointed subject to repeated presidential appointment for 10-year terms or other terms. This is what we're talking about. But their salaries are conformed to district judges. They make $223,400 a year. Most Americans, Americans are listening, obviously there are a lot of people who make lots more than that. But there are many, many Americans who don't make that amount of compensation. And they're watching this, and so all I said was, you mean you're going to also say these guys get to work for 10 years and get to retire at 50? While they make 223? So, or more as it's gone up? So then the response from the chairman was that this is designed to protect the independence of the courts, of these judges. And then the gentle lady from Texas weighed in on that score. So now it's getting pretty interesting. The guardians of the independence of the judiciary are coming forward. The same people who want to pack the United States Supreme Court, who've prompted and cheered the crowds outside the justices' houses while they're trying to make a decision that you don't like, precipitating, if you take the guy yesterday in Homeland Security Subcommittee talking about stochastic terrorism, implying that this guy went out to try to assassinate Justice Kavanaugh, was inspired by that same rhetoric. You're our guardians of the independence of the judiciary. But the legitimate way to control the judiciary is what is the mechanism of presidential appointment, confirmation by the Senate over time. That is what you guys call packing the court, by the way, when you apply it to the Article III courts, the Supreme Court most of all. So all I'm talking about, well, just one second, let me finish the point. All I'm saying is this is just pure common sense economics and regulation of an employment system that is also serving a very important judicial function. But they're employees. To give them 10-year service and then you can just retire at 50 and just say, well, the only explanation I'm going to give is because we do other judges that way. Maybe we shouldn't have gotten there for other judges. But I don't think you improve it by expanding it. Is there somebody I'm supposed to yield
It's
to?
Andy's.
I don't have the time to yield, Mr. Chairman, but I'll yield back to Mr. Biggs.
Mr. Biggs, yield for a second.
Thank you, Mr. Chairman. Mr. Chairman, at best, this legislation is unnecessary. At worst, it adds bureaucracy and centralizes more power in the Department of Justice rather than leaving important decisions to the states. According to a 2020 report from the Government Accountability Office, every state has at least one alerting authority. As of 2019, there were more than 1,400 alerting authorities across the country, and FEMA had more than 400 pending applications. Federal, state, and local officials already use the integrated public alert and warning system to send emergency alerts to mobile devices and the emergency alert system to alert media platforms. According to FEMA, these alerts are used for, quote, natural or human-made disasters, extreme weather, active shooters, and other threatening emergencies that are current or emerging, close quote. If the states are already using an alerting system to notify the public about imminent threats, why do we need this legislation? All this legislation would do is add a layer of bureaucracy and inject the Biden administration's heavily politicized Department of Justice into what states already do. We have no idea what the unintended consequences of rolling out a nationwide active shooter alert system might be because this committee hasn't studied the issue or held any hearings on the topic. Instead, the bill requires GAO to study state and local responses to active shooter situations and situations involving the issuance of a public alert or warning. Why don't we study the alleged problem and learn from the findings before legislating a solution to it? It doesn't make any sense. The best way to combat crime and violence in our communities is to support law enforcement rather than to demonize and to seek to defund them. This legislation is counterproductive and unnecessary. I'm afraid it's simply an attempt from the Democrats to look like they are doing something about the surge in violence and crime across this country, but they're not doing the things that need to be done to address it. I yield back.
I will yield to the gentleman from North Carolina.
Thank you, Mr. Tiffany. And, you know, I had another thought. So your point's well taken. And maybe Mr. Cicilline said that law enforcement was offended by the amendment, and I didn't see what was offensive about it. Maybe I could direct question Mr. Cicilline. I don't know whether it'd be, you'd have to yield to him, Mr. Tiffany, but I wonder why he would not also want this system, if it's needed, if it's not surplusage or redundant for systems that already exist, why not make it available to, in the case of the Waukesha killer who ran down people with an automobile and fled, you know, before. But maybe even a better example, or another example at least, I think of the 2013 Boston Marathon bombing by the Tsarnaev brothers and the manhunt that followed from thereafter. That was a bombing, not a shooting. It was a mass killing event. Why wouldn't, I wonder if Mr. Cicilline would yield to answer why not extend this to reach those events and others like those that Mr. Issa was reaching for.
I'm happy to, if you're yielding to me, I'm happy to. You know, I think this is like, in many ways, arguing that the Amber Alert system should be expanded beyond kids and maybe to shoplifting or other crimes. Look, this is for a very specific and urgent problem. Active shooter incidents that are deadly, that are endangering the lives of law enforcement. And it's funny, despite all of the deep respect I have for all of you and all of the conversations with 6 national law enforcement agencies, they all agreed that this was a very specific problem. And not one of them, these are the brave men and women who are actually responding, or risking their lives to keep us safe. No one suggested that we had 5 other things we should include in this category. This is a specific and deadly problem. We've had more shootings than days of the year. And the men and women in law enforcement are the people who are in danger. So they've made a judgment by making this a #1 priority for Police Week that this will help save their lives. I think we ought to believe them. If you want to write another bill about car accidents, happy to work with you on it, but that doesn't seem to be as an urgent problem right now as active shooting.
The gentleman's time has expired.
I listened to this and I'm not sure I can articulate what I'm thinking, but the ferocity of the response to what Mr. Issa has offered is sort of an anodyne, straightforward, logical modification of this is telling to me. The insistence and even the characterization that it offends law enforcement agencies or law enforcement associations nationwide to broaden the term, and the examples that have come out in the offering of Mr. Tiffany about one in an automobile running people down. I came up with the example of the Boston Marathon bombing and people being on the run from that and dangerous. Mr. Issa just came up with another example. They all logically seem, if there is not, I mean, I think the first instinct with which I approached the bill, and having opened with the ranking members, given the ranking members' comments on it at the beginning, it was that it strikes me as very likely redundant and additional bureaucratization of something that is already all over the place, and we've all experienced it. Now, I confess that I don't have the intricate knowledge, so I was listening for why this fills in a gap or does something important new. But when we get to the question, if it fills in a gap, you want to make it as more comprehensive, make sure things are covered, and then Mr. Issa offers an amendment that would change the name. The hostility to that, because it doesn't say active shooter, it's almost as if, I even hesitate to say it, but it is almost as if the majority is anxious to sensationalize that very concerning phenomenon of the rise in mass shootings that has occurred in the past 30 years as Democrats have destroyed our culture. So I don't see what the point is unless you're trying, and then of course, Ms. Dean concerningly described this bill about an alert system as gun legislation, which I think gets us to the heart of the matter. It's important for you to have this title to the bill, and the title to the bill drives the purpose of the bill, which otherwise seems to be redundant. so you can spread the panic more about mass shootings rather than address their underlying causes. And with that, I yield back.